Many people think that just because they slipped and fell on someone else's property, that person is responsible for the injuries that they have or for paying for their medical treatment. That's not necessarily true. Colorado has a Premises Liability Act that tells us exactly what we have to prove in order to show that someone else is responsible for your fall and your injuries. The Premises Liability Act is complicated and it has a lot of requirements, so I'll go through the basics for you so you can understand what it is that we need to show. First of all, it depends on why you're on the property, what you're doing there, what the purpose is, and then it depends on what caused you to fall, what caused your injury, and then the trickiest one is notice. Notice is a protection that the Colorado State Legislature gave to landowners that states that they had to either know or they should have known that the dangerous condition existed before you were injured by it. Notice is a protection that the legislature gave property landowners to keep them from getting sued for a dangerous condition that they didn't know existed or shouldn't have known existed. So as a plaintiff, it's your job to prove that the dangerous condition that caused your injury is something that the landowner knew about or should have known existed so that they could have done something to remedy it before it caused your injury. Let me give you an example of a recent case we had. My client was leaving his apartment complex in the morning before he went to work. He was going down the front stairs and slipped on ice. He called us and I said, there's a lot of questions that I need answered before I can tell you if your case is going to be successful. One of them is to look at the forecast. We needed to know if there was snow or ice in the forecast and if the apartment complex should have known that there was going to be a dangerous condition. Then we needed to know whether they put something out in preparation for the dangerous condition, like salt or sand, and if they had done any shoveling before it even got there. After the snow and ice, we needed to know if they then went out and did remediation. Again, did they put down sand or salt? Did they shovel? When they were doing the cleanup, if they did it, and the remediation efforts, did they follow industry best practices? Or did they just follow their internal policies and procedures that don't meet with what the rest of the industry is doing? Had the snow and ice been around for several days, and did my potential client know that it was there and continue to use that stairwell? All of these are points that the legislature says we have to prove as plaintiffs in order to show that the landowner is responsible for the injuries and the medical bills that accrued as a result of the fall. Another common example is when our clients have walked into an establishment like a 7-Eleven or a gas station or a grocery store, and they go back towards the frozen food section and they fall. Do we know if that's from something that another customer spilled? Do we know if that's from mopping? Do we know if that's from a freezer leaking? All of these we have to know. We have to investigate and we have to prove that whatever it is something that the premises should have known about or already knew about and failed to protect their customers. These cases are more complicated than they appear. It's very easy to think you have a case when you don't, but it's even easier to think you don't have a case when you do. You need someone to help you that can do the proper investigating and knows the laws in Colorado to protect you. Call us and we'll help you with that.